Good morning and a big welcome to day 2 of the 2021 Global Forum on Responsible Recruitment. Yesterday we had a big day going through the high-level political opening, a session looking at how fair recruitment can benefit all stakeholders, another on how to better regulate, and then a specific look at the agricultural sector. This session will unpack the barriers migrant workers face when attempting to resolve their grievances. We'll look at practical solutions to support migrant workers seeking compensation, even after they return home. And we'll discuss the role that business can play in terms of company-level remediation, as well as strengthening state processes. We'll also consider how a migrant worker's gender and regular or irregular status affects their opportunities to access justice. In the course of the discussion, our expert panelists will share different models for enabling and supporting workers to access justice and resolve grievances, including cross-border case management approaches, company-level grievance mechanisms, and access to criminal and civil court proceedings. We have translation into French available for this session. To access the translation, please select the language icon on the right-hand side of the screen. You should see a small globe image. At the end of the session, we'll have around 10 minutes for Q&A. Please post your questions in the Q&A sidebar and upvote any questions posted by others that you would like to have answered. Please also use the chat to share information and resources, and we'll be posting links there to resources mentioned by the speakers. It's now my great pleasure to introduce the panelists for the discussion. Douglas McLean is the Executive Director and founder of Justice Without Borders. An expert lawyer on cross-border civil litigation for migrant workers in Southeast Asia, Doug leads a team of experts focused on making access to justice more efficient, effective, and affordable for workers even after they return home. Parichat Jaranon is the chairperson of the Federation of Asian Domestic Workers of Hong Kong, otherwise known as FADW. FADW is a union federation composed of local and migrant domestic workers union in Hong Kong of different nationalities. Parichat is both an advocate, a unionist, and herself a domestic worker. Mustafa Kadri is the founder and executive director of Equidem Research and Consulting. He's a human rights research and advocacy expert with 20 years of interdisciplinary experience in government and public international law, journalism, and the non-governmental sector. Greg Chen is the CEO of PT Outsource Indonesia, a formal sector company specialising in private placement, recruitment, payroll and HR managed services. He also holds a number of leadership positions at business and sectoral organisations, including as a board member of the Indonesian Outsourcing Association, ABADI, and the Employers Association of Indonesia, APindo, as well as the World Employment Confederation. And we're delighted to have these speakers with us today. For the past decade, I've been researching migrant workers' access to justice for recruitment-related violations and in recent years for wage theft. What's been so striking to me about this work is that although there are always context-specific factors, the barriers to migrant workers accessing justice are remarkably similar and persistent across countries and corridors globally. For example, weaknesses in state judicial and non-judicial processes often result in a low likelihood that a migrant worker can obtain a swift and fair remedy. These include the lack of a professionalised and rights-based mediation process. Often they include a lack of legal or paralegal representation, which is essential for virtually all migrant workers to access any type of process, whether it's court, mediation, or business-led processes. Often there's weak enforcement of judgments and limited consequences if recruiters or employers don't show up to the process at all or don't comply with judgments. And there are general barriers to access associated with long processing times, costs of claims, and overall lack of transparency and due process. Migrant workers also face a range of practical barriers to accessing remedial mechanisms, including the time and effort required to make and pursue claims, especially when the worker has to work and deal with other pressing needs. They also encounter geographical barriers, including centralisation of remedial mechanisms in capital cities, which are often very far from workers' homes, particularly in villages. Many migrant workers are either unaware of their rights and or unaware of processes for seeking remedies in relation to recruitment abuses. They also face significant obstacles to marshalling evidence required for a claim, particularly if they've paid a recruiter in cash or if they've received falsified receipts. In addition to these practical barriers, accessing remedies often comes with significant risks for migrant workers. Many workers face risks of retaliation by the recruiter or the village broker against the migrant worker or their family. Bringing a claim against a recruiter or employer may also jeopardise the migrant worker's ability to get placed again if they want to work abroad. And if the migrant worker is still in the country of employment, could result in them losing their job and consequently their visa. Finally, there are a range of psychological barriers that impede migrant workers from seeking to remedy recruitment abuses. Some workers are resistant to taking action when they see other workers around them aren't taking action. Others are pessimistic that they can obtain a remedy at all or that anything will change as a result of their claim. Some are embarrassed to acknowledge or reveal to others that they had been taken advantage of or that things had gone wrong for them abroad. Others may feel a sense of loyalty to their employer or agent, or may culturally defer to their perceived superiors and be reluctant to be seen as a troublemaker. The good news is that trailblazing organisations like Justice Without Borders are developing innovative programs and approaches to overcome some of these barriers and improve migrant workers' capacity to access justice for recruitment and employment abuses. So I'd like to open the panel today by asking Doug, in Justice Without Borders work across Hong Kong, Singapore, Indonesia and the Philippines, what are some of the most common recruitment-related violations that you come across? And also, based on your experience, how can migrant workers employed across different sectors secure compensation or redress for recruitment-related abuses, including the reimbursement of illegally charged recruitment fees and related costs?
Bassina, thank you very much for that question. And thank you to everybody watching today for having me on and for listening to the presentation. Great question. And you covered in your introduction a lot of the issues that prevent workers from seeking compensation when they're illegally overcharged. And I want to talk about illegal recruitment fees in particular in terms of how workers can go about getting the compensation that they need. I have a couple of short slides just to set context. So if I can ask for some help putting those up and seeing where I'm at on that, I'll be able to take this forward. While we're waiting for that, let me just set the scene here. So Justice Without Borders deals specifically with cross-border action. Because as we know, migrant workers are incredibly mobile, and the issues that they happen to face can take place before they leave, in transit, once they arrive, and they can continue after they have moved on to somewhere else. So our work is about making sure that workers still have access to the local laws and regulations that might provide them with a right to remedy. The issue, of course, is that there are still very few international regulations that provide real enforceable protections and rights. So we're very much looking at local remedies in the local countries, particularly in source and destination countries. We work through partners to make that access to justice possible. You can trouble me for the next slide, please. So, as Bassina had said, our work is about making sure that access to justice is efficient, effective, and affordable. And that when a worker has a problem, they're able to seek legal assistance and a remedy wherever they are for wherever the problem happened to them. Now, one of the most common issues that we see across all of our jurisdictions, and truly for almost all of the workers that we are working with, are illegal agency fees. And this isn't just an issue of overcharging. It is an issue of putting them into debt bondage, cutting off assistance to their families who may need it, and making it that much harder for them to make a better life. So in speaking about this common issue, I want to really highlight how specific it can be along the migration route. The strategies for getting remedy might be the same, but depending on the migration route, the way you go about doing so might be a little different. So let me share one strategy we've been using that works particularly well along the Indonesia to Hong Kong migration route. This strategy might also be applicable for you in your own particular context. So many domestic workers from Indonesia go over to Hong Kong for work. Before they even leave the country, they are saddled with multiple months of debt. They don't pay it up front. They go over to Hong Kong, the agency over there picks it up, and they force the worker, either directly or through a loan company, to repay the debt. A lot of our work has been going after these illegal fees that started in Indonesia over in Hong Kong. But recently, we had an opportunity to actually flip the script and to go after bad employment agencies over in Indonesia. Here's the story. We had approximately 21 domestic workers who our friends over at FADWU had identified as victims of overcharging. They had evidence even. Problem was, as Bassina was saying, they were very hesitant to bring up this issue with their agents in Hong Kong because they had just arrived, meaning that they would be going silent until they went home, potentially years later. Instead, however, we and our partners at FADWU and at SBMI in Indonesia decided to help the workers make a claim over in Indonesia while they were still abroad in Hong Kong. And we were successful. We aggregated the evidence with the clients. SBMI took it forward to the government. And the government forced mediation upon the agency. Outcome of the mediation was a settlement that brought back most, sadly not all, but still most of the illegal fees back to the workers, basically cutting their debt short by multiple months, making it easier for them to make the better life that they were hoping to do over in Hong Kong. Best of all, the agency had to agree to provide the names of other workers who went at the same time. They provided those names to our union partners so that they could follow up with those workers as well to see if they wanted to make a similar claim. Best of all, the Indonesian government agency responsible for regulating these employment agencies put that agency on notice that if a similar complaint came up again, they could very well lose their license. So this new sort of reverse cross-border actually helped these workers recover their fees long before they had to go home, and they could continue on with their lives in Hong Kong. And I'll end my presentation here. Thank you very much.
Thank you very much, Doug. We're now going to have a poll for all of our participants. You should be able to see that on your screen now. And I ask you read the question and select one response. The question is it possible for workers in your context to seek compensation for violations suffered abroad after they return home? And you have 5 potential options. It's impossible, it's possible in theory, it's possible for some migration routes, but not all, it has not been tried, or I'm not aware of the processes available. So if everybody could select one of those responses, we will then display the results for you and return to Doug for his comments on those results. Thank you, everyone, for participating. I'm just waiting for those results. Okay, so we see that a very small number, only 4%, have said impossible. The largest group have said possible in theory, suggesting that there may be some theoretical way for this to happen, but in practice it's not happening. About a third of you have said it's possible for some, but not all migration routes. 4% said had not been tried, and 21% said they're not aware of the processes available. So this suggests quite a large proportion, at least so more than 2/3, have said that it is either possible in theory or possible for some migration routes. Doug, obviously access to justice upon return is something that you address on a daily basis. I'd be very interested in your reaction as you see the responses to the poll and what lessons you've learned in your work and what approaches are transferable across sectors, countries, or migration corridors.
Absolutely. The possible in theory part is basically our experience for the last 8 years. On paper, a lot looks possible. The question is what's actually doable in practice. I think it's also correct to say that it really does depend upon the migration route. The way we approach this is we look at the laws in the source country and the destination country, and we put those together. And that really does give you an image of the rights, responsibilities, the enforcement mechanisms, basically that legal system for that migration route. We begin by looking at that on paper. Then we look at, well, what's actually been done in practice? And that could be anything from looking at research, actual cases, talking with people on the ground. Generally, you're going to find a mix of things that have been tried and were successful, things that were tried that weren't successful for various reasons, and then things that weren't tried at all. So the learnings that we have from our own migration route, and that we will certainly use when we expand to other migration routes, is to first understand the theory, then see what would be the low-hanging fruit. What types of claims seem to be the most doable? Get a sense of who the stakeholders are along that migration route who can help. Not just lawyers, but paralegals, nonprofits, legal faculty, government agencies that are friendly. There's quite a number of different groups that are already helping workers on the ground and can make that connection between home and host countries. The biggest learning for us quite often is that it's less the law and more the logistics that can really get in the way. You mentioned lack of evidence before. That's a key issue. And so for us, it's innovating new ways of obtaining the evidence that's out there. And what that's going to be is going to depend on the migration route, of course. Most importantly, it's also to recognize that litigation itself may not ultimately be necessary. We've had more than enough cases where just reaching out to the other side, the bad employment agency, the bad employer, with threatened legal action can start to change behavior and can lead to a settlement, even when evidence isn't necessarily all that strong. I do very much agree that there are some migration routes where this is not possible yet. You really do need to look at the laws and the destination and the source countries and see them in practice to understand what is possible. If it's not possible yet, that does mean that legal reform is necessary. But we've been surprised to find that for a lot of migration routes we looked at, there's at least some remedies that are practically possible, but they still need trying.
And Doug, what do you find are the claims that are most amenable to being brought cross-border? What types of abuses?
Yes, surprisingly, agency fee ones can be quite amenable, particularly when we start to set an agency in the source country against the agency in the destination country, basically threatening legal action in parallel. And that can start to drive a wedge between the two and lead to good outcomes. For other cases, particularly where we're talking about abuse that's been documented, that can really start getting the gears of justice moving. The hardest ones, on the other hand, are those that really don't have any evidence at all. But for us, it's abuse and agency fees that seem to be the most doable, at least within our own context.
Thank you for that really fascinating and inspiring description of the work that you're doing. And it sounds like this is the tip of the iceberg and hopefully can be replicated in other corridors and jurisdictions, and that Justice Without Borders is moving in that direction itself as well. So we will all keenly watch as you develop this work across other corridors as well. I'm going to move now to Parachat at Farbenblum. Parachat, Fadwa has completed different pieces of participatory research about the recruitment and employment of domestic workers in Hong Kong. What are some of the main findings and recommendations from your research?
Yes, Fadwa carry out qualitative research, semi-structured interview by reach out with 33 migrant domestic workers who assess a labor department redress mechanism in 2018 or 2019 to try and resolve work-related problem. The main findings are the cost and the time. The average time interviewee in the current research have to wait between filing their case and having it settled at the Minor Employment Claim Adjudication Board and Labor Tribunal was 58 days for 12 interviewees. This is very long time consuming, and this makes the migrant domestic worker difficult to access to the justice. And a migrant domestic worker who take a complaint to the labor department lost their job will generally be left with nowhere to live This is because the 2-week rules stipulate that the migrant domestic worker must find new employment and process the visa within 2 weeks once their contract is terminated or leave Hong Kong. This is extremely difficult to do. The biggest expenditure for most migrant domestic workers will be the cost of their living expenses, such as the visa extension fee, accommodation, food, and travel costs. During the weeks or months it may take to resolve their case, it is the cost along with not being able to work, which makes the redress process too expensive for majority of migrant domestic workers. Also, migrant workers also losing their income while their case is going on, while it put the big impact to their family in their original place. Recommendation for the Hong Kong government is to repeal the 2-week rules and ensure the migrant domestic workers have sufficient time to secure a new job after the contract has been terminated, and thereby are better able to pursue redress mechanism, and grant on migrant domestic worker with a pendant case in the conciliation service, minor employment claim adjudication board, labor tribunal, or criminal court visa extension, which allow them to work while their case is being pursued and waive the visa fee. And you can see more the recommendation in the chat box.
Thank you, Parachat. You raise a very important issue of the connection between immigration and employment, and how important it is that the migrant worker is able to remain in the country and able to work and sustain herself if she is to pursue a claim, because without that it becomes very difficult. And I think that's the case in most jurisdictions. Can I ask you also, based on your research, what are some of the general strategies that you can recommend to reduce the costs that migrant workers face when accessing justice? Because obviously this is a very significant barrier for migrant workers actually bringing claims rather than simply returning home.
Yes, general strategy for Federal to recommend to reduce the cost migrant domestic worker face when assessing is a waive extension visa fee while the case is going on. Repeal the 2-week rules so the worker can continue work while the case is going on, and minimize off time is working the case. Filing case is more reachable and must fully understand and access to shelter for those with no other means of supporting themselves while pursuing their claim.
Thank you, Parachat. I think those are all very important strategies. And obviously there's also a very important role to be played by diplomatic missions and consulates of migrants' home countries in supporting them, as well as those strategies to be employed by the country of employment. Parachat, how has FADU supported migrant workers to access the labour courts in Hong Kong?
Yes, Fed will have a case team to provide the support the workers. The team has allowed 15 members with different nationality. Federal case team have training for the case handling, so they know how to handle the case. The first step usually Fed will do is first interview to the workers who file case in court. Second, explain or orientation on the process step by step to the workers. The third is help to draft their statement. The fourth, assist worker to filing and explain the procedure if it's already accepted in court. And the last, if the workers want us to be represent them, and then Federal will represent them and help them throughout the process until the case is settled or closed.
It's an amazing service that you're providing. And I think in every jurisdiction that we've ever looked at, one of the greatest barriers is that legal or paralegal assistance, because we know that migrant workers cannot access any of these processes without that support. And it's really extraordinary that you have formed a group so large to be able to support domestic workers in this way. It's a really inspiring story, and I hope that others are able to learn from it in other jurisdictions. So thank you very much for sharing that. I'm going to turn now to Mustafa at Equidem. Mustafa, Equidem is currently working on research on fair recruitment and access to justice for migrant workers. What are you finding in relation to the impact of gender and migration status on migrant workers' ability to access justice?
Thanks, Bassina, for those really key questions, and also thank you for having me on this really, really great panel. So, yeah, when it comes to gender and migration status, those are arguably two of the most sort of vulnerable broad categories of types of workers when it comes to exploitation and other grievances when you have recruitment. In some respects, it's really obvious. If you are a woman, the systems are not set up really to take account of your requirements, the types of work situations that you might be facing, and also the drivers for you seeking a job. If you are of an irregular or informal migration status, for example, you may have gone for a certain type of visa category, but the way that visas are traded illegally means that, in fact, the kind of work you're getting doesn't really align. You might even end up being trafficked because of the informality of how you're recruited. Well, in a way, it's kind of obvious that by definition that you're more likely to face exploitation. But I think that from the research that we've done for a paper that we're drafting for the ILO on worker access to justice and recruitment is, these things become a lot more complex the more that you look at them. And if I break it down in terms of, the two categories, which are very broad, of course, much more complex than that. But with gender, one of the things that we really see very sort of starkly is that, firstly, in some countries, the way that countries try to deal with exploitation is to effectively restrict women's access to lawful channels for recruitment. The idea being that, of course, it's not a safe environment for them to go, or there should be highly regulated spaces where they can do that. But what that really ends up happening instead is that women are still going to work because they need to work, and there's lots of social pressure on them often to find work overseas. And that leads them into these channels where things are very highly unregulated and informal. Another thing that we see is that workers simply just don't have much of an understanding of their rights, and much of our job is to really educate them. So, for example, we know that in general, women face a whole range of discrimination in the recruitment process. Yes, that's about recruitment fees. Yes, that's about exploitation and vulnerability. But it's also simple things like the wages that they will earn for the same work as a man. And yet many women actually aren't really even aware of the fact that they should be getting paid the same amount of money as a man for the same work. That's an issue. So that's a really key area that you really need to think about. Now, what also happens is that the process of transition from their country of origin to the country where they're working, a bit like what Doug was mentioning earlier, is that this is a transnational process. Now, these are, basically speaking, very male-dominated environments and experiences. And so what that means is that there are lots of challenges for women going through that transition process. If they've had a range of exploitation, experienced that in the recruitment, and they end up finally in the country of destination, there's very little space for them to make a complaint, even if they're aware of their rights. I mean, some of the things that we've seen is that, for example, some employers or even regulators have an attitude of locking women in accommodation sites after a certain time, like a curfew period, putting them in irregular locations because there's often much smaller populations of women than there are male workers, which of course goes beyond recruitment, but has an impact on their ability to then access services, access help if they're in a situation of difficulty. And then, of course, there's the other element of the unfamiliar environment that they might face themselves in, not just women workers, but, of course, or a range of workers. But this can really affect women. So that, for example, if women are traveling from Asia to the Gulf, there are very different cultural practices, expectations around women in the public space. There are certain crimes on the statutes which basically criminalize women disproportionately in a range of ways. And so women might be exposed to that. And of course, then all those things that I said apply also to domestic workers who are overwhelmingly, although not entirely, women. But of course, the domestic workers face profound vulnerability to exploitation because, firstly, there's generally a much weaker regulatory framework when it comes to domestic workers. And of course, their workspace, the home, is a much more difficult place where labour protections can be enforced. Very briefly, to talk about migration status. Again, a lot of overlap with a lot of other worker categories, with gender as well. But very briefly, one of the fundamental problems you will face globally, whether you're in the United Kingdom, where I am, or you're in Malaysia or in the Gulf countries, anywhere in the world, not just those countries, is that systems are very efficient and very good at criminalizing workers who don't have the correct visa category, the correct visa status. They will often criminalize those people when they actually seek help by going to the authorities to complain about something. So that's a huge, significant challenge that we face. Of course, the other thing is that the market conditions are such that, like in any labour market around the world, there's a huge demand for workers who can work flexible hours and in an informal capacity. And yes, workers ostensibly are required to get a certain kind of very rigid visa category. And there's a lack of basically reflection of work patterns of people coming in on basically in informal ways on the non-traditional visa categories. And so the systems, again, are designed to look at full-time employment over a period of contractual employment, but not really designed to factor the kind of vulnerabilities that these workers in an informal situation might be in. And yet the situation for these workers is not really rocket science anymore. It might be challenging sometimes to identify these workers, to find out what the situation is. But quite frankly, from the moment that these people land at the airport, it's really not rocket science to work out that this is a very vulnerable worker purely by the nature of the visa category that they are they're coming in. So yeah, in a nutshell, gender and your migration status plays a huge role in both your risk of exploitation in the recruitment process and also the challenges that you're going to face in seeking any kind of help or justice or remedies for that exploitation.
Thanks, Mustafa. And you spoke about gender discrimination in terms of pay levels between men and women. I'm wondering, based on your research, what you think can be done to ensure greater equality and fight discrimination. And that might be gender, or it may be in relation to migration status, whether it is sort of migrant or non-migrant workers or migrant workers in regular and irregular status, and whether there are any good practices that you've identified in this regard.
Yes, that's a really key question. So obviously it's a huge challenge, and Bassina, as you said, it's not just to do with gender or those in an informal status. It cuts across a range of migrant worker situations. What we've found is that one key step, which sounds really obvious, but is to really try to address issues at the source. So we know that recruitment is often the first step in that cycle of exploitation that a worker faces, typically because they pay illegal fees. But we also know that workers will be subjected to contract substitution, coercion, or deception in the recruitment process. So a really key first step is to really get a clear sense of, is the worker going for the job that they will actually be doing when they end up in the destination country? What is their visa status? Who is their employer? In this current age, when technology allows us to connect practically with any corner of the globe, the ability for us to really do that monitoring, oversight, and due diligence from both where the person is getting formally recruited to where they're ending up with an employer, there might be complexities there, but that's an area to really look at. So it's really about initially finding these workers at the source and making sure that process, that initial process, is really key. I think a second thing that really comes up, although there's obviously many aspects to this, is allowing workers to have some, good access to mechanisms to lodge a complaint. and recognizing that just like all of us, every individual and every community is different, and they will seek help in different ways for a range of reasons. So therefore, not just, for example, relying on, a government desk at the airport or a phone app or going to your embassy, but in fact having a range of different options available to workers to lodge a complaint, but making sure that there is coordination and centralization of those opportunities workers have. And that also makes that any training or education that you might do of workers as to their rights and how they can lodge a complaint is more effective, because as everyone knows, when you do any kind of training, but it's not linked to some sort of concrete outcome or recourse, often it feels very conceptual. And I've seen that myself with having sat on many trainings, both in origin states and destination states, is that for workers, it often comes across as, okay, well, something I have to do, but has no real relevance to me. In terms of the solutions out there, so, there are solutions out there. There's things that we've seen that are really encouraging. I don't want to necessarily name countries or certain providers, because it's interesting. When I and my team were putting together these solutions, we found that there are solutions there, but there are obviously challenges even within those solutions. But to speak broadly, some of the best things we've seen is around setting up visa centers, where basically workers have to go through that one place to get processed for their contract, for their visa, to lodge all their details. Now, that does not address lots of other issues. What we're seeing in some of the examples that we're currently looking at doesn't deal with illegal recruitment fees, but it seems to have done a lot in terms of dealing with contract substitution, the practice of basically saying to a worker, oh, here's your job, here's your pay, here's a description of it. But in fact, what they're actually doing is something quite different, often much worse. So that's been a really key part of it. The other critical aspect of those centralized places for registration and those processes is getting a very clear and quick sense of who is the worker, what's their biometric information, where they're from, who are their next of kin, so that if something happens to that worker, and even if they disappear in the country of destination, we can track them back. There's been another sort of very quick solution, a quick point to make about solutions is that in terms of remedies and helping workers to access help, in our research, we've seen in a number of countries that trade unions have been absolutely essential. Worker representative bodies and civil society as well have also been really key. But as Doug and other speakers have mentioned, it's really key where possible to have trade union bodies and members involved in that process of helping workers. They are themselves workers, they have those networks with workers, and they're able to communicate the opportunities available to workers in a way that workers will understand and trust. And critically, they can have that discussion, that discourse, that negotiating function with both employers and state regulators. So in a number of countries, which we'll outline in our report coming out in a few months' time, really highlights that as a really key practical solution, because also what that is doing is linking it to the other labour issues that workers face. It's taking a holistic approach to the issue. Recruitment is one of the issues, but of course, when a worker comes to you, as many of us will know, is that they're not necessarily just facing a recruitment issue. They might be facing other issues, and of course, we should be trying to address all those issues as best as possible.
Thank you very much, Mustafa. I think you raise a number of really interesting and important points there, and particularly about connecting all of these different pieces. I think so it's about connecting data across different areas, connecting information given to workers at different points. So work information given pre-departure about complaints mechanisms may not be relevant and may be ignored, but then having that information come back to the workers in their country of employment when it is relevant. Connecting government agencies and connecting stakeholders, connecting unions to others to make this system work for workers across the entire migration journey in different ways. And you've identified some really interesting examples there. Thank you. I'm going to turn now to the business perspective. And obviously, in order to think about what works or what could work, we really need to understand this from the perspective of recruitment agencies and business. I'd like to turn now to Greg. The members of APINDO that you represent recruit migrant workers into various countries of destination, including Malaysia, Taiwan and Japan, and mostly into skilled jobs such as the nursing and tourism sector. We heard other speakers describing recruitment-related abuses that migrant workers encounter. Can you tell us a bit about how your members resolve recruitment-related grievances, including the types of mechanisms they've put in place to prevent and address grievances?
Hi, Bassina, and thank you for your question. Hello, everybody. First of all, let me start with saying that our association represents employers and companies in the formal sector and work with regulators, members, workers, and other stakeholders on labor issues and solutions within the legal framework. Thus, problems happening, including worker grievances in the informal sector and or created by criminal organizations, are out of our scope to be able to address and better left to the state authorities. On worker grievances in the formal sector, it's standard procedure that worker and employer find a workable solution, whether on a temporary or permanent basis, as the employer and worker are most familiar with the context of the problem and best placed to find the solution, make an agreement and implement it. Much of this are already covered during pre-departure trainings, arrival orientation, work contract, government websites, and during meetings or trainings by employers in the formal sector. If a solution cannot be found and all channels have been exhausted, then workers have access to their embassies and or local labor authority. As this problem seems to persist, as the speakers today have shared, and it's a continuous issue brought up during such events and forums such as this, I recommend a long-term solution is to thoroughly understand the business model of the migrant labor placement sector. While there are dozens of receiving and sending countries in the sector, covering thousands of recruiters and millions of workers, about 164 million workers, as shared in yesterday's session, and 90 countries that are receiving, the commonality that binds most stakeholders is actually recruiters, the recruitment sector, a vital actor in the supply chain. And the recruiters are typically paid once for the successful recruitment of one worker, but is asked to be responsible for that worker during the duration of their work contract that can last up to several years, including handling of grievances, sudden resignations, and being the recognized party responsible for the worker's well-being for the duration of the worker's overseas work journey. Some of these responsibilities come with the risk of fines for failure to fulfill parts of the regulation and or financial penalties for failures to fulfill parts of the agreement with the customer. All these risk management, operational excellence, labor relations, and customer relationship aspects of running a professional formal sector organization comes with minimum set of fixed costs and variable expenses as well that doesn't end with the worker arriving at the destination country. Thus, a one-time payment for recruitment-only services, even up to arrival at destination country by the worker, is not sustainable for a professionally run formal sector company. The risk inherent with this industry needs to be balanced with an attractive financial reward worthwhile for a company to commit to this business in the long term. The business needs to be sustainable and therefore can generate continuous monthly revenues. An attractive profit margin will also attract more legitimate and professional companies into this sector and compete, thereby lowering the cost per worker and while improving services to customers and workers alike. The business model the ILO and its members should seriously evaluate and analyze for the migrant labor business sector is the business model employed by the private placement industry, also known as manpower outsourcing, temp staffing, and other names in different countries representing supply of labor. In the private placement industry, the worker is placed under the employment of the private placement company, which services cover recruitment, contract, payroll, issuance of health, accident, and other insurance programs required by the government, grievance, complaints management, and termination of the worker. Companies in the sector generate revenues on a monthly basis from its customers. On each worker placed with a customer, the revenues allow private placement companies to invest in scaling through developing software systems, employee management systems, and risk-based financial contingency planning. We think the time is right to revisit the need to evolve the business model of the recruitment and placement of the migrant labor sector and make the sector financially stronger by applying the private placement business model into the migrant labor sector. Thank you.
Thank you, Greg. Very interesting to think about the connection between these two sectors that are actually addressed quite differently. Just one final question for you before we turn to the Q&A. In your view, how can state regulations and grievance mechanisms better support employers and recruiters to prevent and address grievances?
Good question. Broadly speaking, the sending country can negotiate bilateral agreements with the destination countries to ensure the employers there respect the employer pays principle and therefore set a solid foundation for the citizens that will be sent there. The state can also perform a good service to its citizens before sending them off to a foreign country, particularly first-timers, by facilitating in-person training and orientation, as well as providing online resources for reporting grievances at its own cost. At the destination country, the state can also properly staff embassies with migrant labor specialists who will work with the workers, employers, placement and recruitment companies, and local authorities should problems arise. A good example of state working with all stakeholders to better monitor worker grievances is the Indonesian government requiring sending organizations here in Indonesia to maintain a company Facebook page where workers can communicate their grievances and the regulator can monitor online real time, in addition to having a regulator-run crisis center for complaints. If regulators include many mandatory services a recruiter has to comply with, then the regulations also need to support the business model to ensure the recruiter can cover its investments and costs or additional costs. The migrant labor ecosystem benefits from having legitimate, professional, and ethical recruitment and placement companies, recruitment at the origin country and placement at the destination country. The private placement business model has been validated at some destination countries, even as we speak, where the recruitment company at the origin country forms a partnership with a placement company at the destination country or opens a branch there, and the customer pays the placement company a monthly fee to cover various aspects of the worker's placement, of which part of that fee is shared with the recruitment company. Thus, the risks are shared, and so are the benefits. This allows for professionally run recruitment companies to continue investing in developing recruitment channels at a lower cost to better meet the needs of both the customers and workers while complying with all the regulations. Thank you.
Thank you very much, Greg. I think you raise a really important point about particularly the Facebook and social media. How do we open channels for the feedback and experiences of migrant workers to actually feed into regulation and licensing of recruitment agencies? And how do we link those two areas of disputes and grievances to the licensing and regulation component that enables recruitment agencies to operate? And the Indonesian example is a really interesting one. Thank you so much for sharing your views. We are now going to move to the Q&A part of the session, and thank you very much to all of you who have posted questions. I'm not sure how many we'll have time to get through, but we'll do our best, and I'll try to pose one to each of our panelists to start with. I'm going to pose the first to Doug, Justice Without Borders. Normally, migrant workers pay recruitment fees without getting a receipt or any evidence showing that they've been paid. Do you have any experiences supporting workers in this situation? And what would be the specific measures applied where you have a worker come to you with no documentation?
Yeah, great question. In our particular context, actually, most of the time the workers are going abroad without paying first. It's structured very much like a loan, and the agencies on the destination country side or the employers directly are involved in securing that repayment from the worker's own salary. So a lot of times we're looking at the trail of payments that are coming out of either the salary or from loan agencies in the destination country. At best, it's about reconstructing where those payments are going and seeing if any transfers are happening back to the home country from the worker. Sometimes we have to work backwards, actually. If we get a worker who's been working abroad for, say, 2 or 3 years, they've eventually paid off, and they started sending the money back home after a certain point, we can use the lack of payment before then as circumstantial evidence that payments had not happened, and then start sending lawyers after particularly the destination country employment agencies to understand where the rest of the money goes. And often that's using destination country laws to say, listen, you're only allowed to take so much money. it looks like you've been withholding salary for a lot longer. Where's the money going? And that can start to open up what has happened to these payments.
Great, thank you for that. And I'm going to ask you one more question because I think it's a really great and important question posed by Sadia Hamid. And it relates to technology and digitization, which on the one hand opens up, as we've learned during COVID, all of these new opportunities for workers to be able to engage cross-border or even from sort of geographically disparate areas within one country. But the question Sadia poses is with respect to digitising complaint systems, this may not be very helpful for illiterate or semi-literate migrant workers as they face issues with respect to having to explain their complaint, unable to provide proof or evidence in accessing the internet, in particular for those in remote areas or at home. What are the solutions to such a situation?
Yeah, great question. At least in our context, a lot of times we're dealing with literacy in another language. And again, because migrant workers are so mobile, they might have documentation in their home country and then in other countries in multiple languages. And of course, for some countries, even if it's the home country, it might not be in a language that they speak. What we find in those cases is that the cutting edge of technology is not so as important as tried and true methods of having good paralegal support to be that bridge between the worker and the information that they need to bring their claim forward. So for all of the push around digitization, often that digitization rests upon having good infrastructure of local case support, both at home and abroad, to be successful.
Thank you for that. I have a question now for Parichat from Peggy Sheck. In your experience, do many workers choose to give up their claims because of the time and cost? Oh, we can't hear you, Parichat.
Sorry, I mute myself because the dog barked. Yes, in our experience and in the research finding, many of the workers would prefer to accept their employer offer at the conciliation. Even the employer offer the less than the full amount they claim. As I mentioned before, this is because the worker urgently to need money and they could not afford stay longer in Hong Kong because of the 2-week rules. They can stay after terminate 2 weeks. So they accept the less than amount. Thank you.
Thank you. And I think you raise a really important point about all of the different pressure points on migrant workers to settle for much less than they are owed, whether it's sort of the cost of continuing their claim, the inability to stay in the country, the idea that they might not get anything and something is better than nothing. And so what are often considered to be successes because the migrant worker has got something, if we look at what they're actually entitled to, are far less than they are entitled to in terms of their rights under law, whether it's contract or statute. We have a question now for Mustafa from Arwen Joyce. Would you advocate for a government fund to be set up to repay workers who've been overcharged? The host country government could then take on the burden of going after unscrupulous recruiters or employers for reimbursement, and workers wouldn't have to wait as long for justice.
Thanks, Bassina. I think that's a really excellent question. In short, obviously, every context will be specific, but in general, I would say yes, that's a really good idea. And the interesting thing is that in many countries, workers already pay a small sum in the legal fees that they pay as they get recruited towards some kind of a insurance system, which albeit is mostly to do with when they come back. So I don't see why something similar cannot be instituted in countries of destination. Nearly 2 years ago, we helped the ILO and the Qatar government in the Gulf to set up, we designed the wage fund that the Qatar authorities have set up there. And I'm not in a position to make any pronouncement about how that's been operating, but I think that the principle of having that kind of a fund, which is activated once a decision is made and hopefully is much more quicker than a worker having to wait several months or years, if not never getting access to those kind of support, financial support when they need it is really key. The thing to stress, though, is that it's not just about that kind of a fund, although that's really important. It's about other kinds of protection for other kinds of exploitation that happen in recruitment. And going back to what we discussed earlier, which is to say that the legal frameworks are set up in a way that they're basically hostile to a lot of migrant workers. And of course, like we talked about, women workers or those in an informal employment setting are particularly vulnerable to that. So those funds and those systems should be, yes, about getting workers reimbursed their wages or other fees that they've illegally paid, but also to ensure that other issues around their support. I mean, something that we see on a daily basis is that when workers aren't paid or are under debt bondage, it's not just the money, but there's profound psychosocial impacts on them. They often are in a humanitarian situation. So those efforts around a fund should also be trying to cover those other things, as we talked about when we were advising the ILO and the Qatar authorities around the fund that they set up there.
Thank you very much, Mustafa. And I think the idea of insurance is a very interesting one, and we see it in different areas of the migration journey, whether it's the insurance that's sort of mandatorily paid along with recruitment in countries of origin for health or other issues, or whether we think about it in the wage theft and other contexts. But it's certainly an interesting area to explore in the migration context. We just have one very final quick question here for Greg from Fahad Al-Karim. Currently, few migrants are able to join the workplace from their home country, and I assume this is related to COVID. Considering this situation, how can we ensure compensation or ensure justice? And I might just frame that question more broadly. How do we think about access to justice in the context of COVID and workers who either paid their recruitment fees and could never go to their job, or paid recruitment fees, went to their job and then had to go home and are left with a large recruitment debt? How do we think about access to justice in that context?
Okay, Bassina, thank you. That's actually an excellent question, and we covered it in a separate event. I think, again, going back to what I was sharing earlier about looking at the business model, and when we have agreements, bilateral agreements between countries, when we have agreements between the sending country organization and the receiving country organization, and then to the end user employers, if we have an evolved business model where the employer is actually a legal entity at the receiving country, at the destination country, then all these issues, including force majeure, which basically the pandemic is a force majeure situation, should be covered in the contract. So it would be very clear on what steps need to be taken, whether that there's an insurance program that needs to be taken in case there are issues like this that come up, or whether the government at the destination country should step up, or whether some of these points need to be negotiated from the very beginning between the sending and the receiving country, so that the workers don't end up in a situation that in a no-win situation, a very difficult situation where they lose their job, perhaps because the employer also do not have the funds to pay them any longer due to the pandemic, having to return home and cover their own costs, and of course having a lot of other financial challenges that comes with this kind of situation. So we think that if everything is governed and documented transparently via a better business model than perhaps what stands now, then that could be a path long-term to ensure that this ecosystem gets better. And some of these issues and grievances and complaints that we heard today can end. There should be a stopping point. It shouldn't be something that we continue to discuss decades later with no end in sight. Right? So if we are continuing to repeat the same, hearing the same problems and the same solutions and applied, and the problems still come up, then we need to find more permanent alternatives that maybe we haven't thought of before. And in the private placement industry, at least, that I'm a part of, that a lot of our members are also a part of, we find solutions that way because it's very clear who is accountable for that worker. And the company, at the end of the day, is responsible for the worker that they employ, responsible for their salaries, responsible for their insurance, responsible to report them to the government, and responsible to communicate changes and regulations and to compensate them properly through the regulatory systems. Thank you.
Thank you, Greg. I think you've laid down a really important challenge to recruiters in this sector to learn from the recruitment of workers in the areas that you're working in, and to really think about how we achieve that level of responsibility that you have achieved in the sectors that your members are working in this space of lower waged migrant workers. We're almost out of time. There were so many fantastic questions, and I thank all of you for your really terrific engagement in the discussion. Thank you so much to each of our panelists for your really important and thought-provoking contributions to this session, and to each of our participants for being part of the session and for your wonderful questions. I hope you have an opportunity to engage with the panelists at another stage to have your questions answered, and that this is the beginning of a really important discussion that we need to continue learning from the really terrific work being done by each of our panelists today. So thank you so much. Before we close, I'd like to remind everyone that in 30 minutes there is another session that will begin on improving enforcement of regulation at all levels to drive progress, and everybody is invited to attend that session as well. Thank you very much.